Welcome to the weekly statutory knowledge sharing webinar organized by Mehta and Mehta. As friends, you know, this is a webinar series for the Companies Act. And today's our webinar topic is an insight into the issue of securities on right issue and private placement basis. We have with us our presenter, Ms. Kinjal Mistry. It will be presented by Kinjal. She is our associate partner. Thanks, Kinjal. We have with us Mr. Rajiv Malik, today's panelist, Deputy General Manager, Legal Noida Manufacturing, LG Electronics India Private Limited. To formally introduce, Mr. Rajiv Malik is Deputy General Manager, Legal of Noida Manufacturing, LG Electronics India Private Limited. He's a CS as well as lawyer. And he's a seasoned legal professional with wealth of experience in various aspects of the legal field, including litigation, contract management, data privacy, antitrust issues, and compliance. With over 20 years of expertise, he has made significant contribution to corporate world and specifically to LG. During his career, he has demonstrated strong commitment to achieve favorable outcome for his clients. Mr. Rajiv Malik is a qualified company secretary, which gave him comprehensive understanding of corporate governance compliance, which allows him to assist organizations in meeting their legal obligations and minimizing risk. He is dedicated to promote ethical practice and ensure that business operate within the boundaries of law. Mr. Rajiv is also postgraduate diploma in cyber laws, which provides him a unique perspective on the legal challenges presented by the digital age. His passions for sharing knowledge and insights extend to his frequent speaking engagements at conferences, seminars, legal conclaves, and corporate events. He has talent for simplifying complex legal concepts and engaging a diverse audience with practical insight and actionable advice. His goal is to empower individual and organization with tools and strategies needed to thrive in today's legal landscape. Welcome, Mr. Rajiv Malik. Thanks for your time, and your passion for sharing knowledge brings you here also. Thanks for that. Thank you very much.
Thank you. Thank you
with
so
us,
much for the.
Thank you. With us as friends, you know, our other panelist, our moderator, Mr. Bala, who is always with us, and his knowledge and his write-up on the decided cases is unique. Everyone knows him. He is also always sharing his knowledge and contributes articles on various magazines. And he is having company secretary's experience for more than 4 decades. Welcome, Mr. Bala. With us, another stalwart, Mr. Sudhakar Saraswatullah, a prominent panelist, is associated with consultant of his ICSI and Institute of Charter Secretary and Administrator, UK. He has worked as Vice President of Company Secretarial Department of Reliance Industry for 17 years. Welcome, Mr. Sudhakar. Friends, with this, I will request Mr. Rajiv, and we have with us our panelist, Kinjal Mistry, our partner with Mehta and Mehta. And I'll request Mr. Rajiv Malik to say a few words on the topic, then Mr. Sudhakar, and then Bala, and Kinjal, then you start the presentation. Friends, as usual, please put your questions on chat box, and the same will be answered. And at the end of the session, we'll allow others to speak. And I know today the topic is so vibrant. There will be full of questions. People has पैसा आ गया है, यूज करने नहीं मिल रहा है, आपको बिजनेस समझता नहीं. I know CS must be facing from promoters and clients. क्या हम ऐसे पैसे, you know what is the cost of idle money, all that we are listening. And the tremendous pressure, the people will have a lot of issues and questions will be like anything. So over to Mr. Malik. Thank you.
Yeah. Thank you so much. Actually, you have rightly mentioned there are a lot of issues are there for the idle money and other thing. So, formally, thank you for this invitation and the opportunity to share my insights with these esteemed audiences. So, securing capital actually is the lifeblood for companies seeking to flourish and conquer their strategic goals. But the chosen path to raise capital is also very crucial. Selecting the optimal approach hinges on the company's unique financial health, ownership structure, and long term aspirations. So, today we delve into the intricacies of three prominent methods of issuing securities, that is, right issue, private placement, and preferential allotment. By equipping ourselves with the nuanced understanding of each method, I think we can empower companies to make informed decisions tailored to their specific circumstances. But here our exploration doesn't end here. Actually, we will going to tackle some very intriguing propositions that have sparked lively debates. Can right issues be offered at discount to existing shareholders? Can startups leverage technology or third party applications for private placements without running afoul of regulations? Can cash be taken while issuing securities? Is every security having the right to renunciation? And many more like this. So, furthermore, we will dissect the much publicized Sahara case, drawing insights to illuminate the complexities of navigating these capital raising mechanisms. And to further enrich our understanding, we will also take a deep dive into the recent landmark cases concerning private placement by startups, which is really a challenging task these days, and looking into the orders by the court and ROC. These case studies will provide valuable actual insights into the judicial interpretations and how they shape the practical application of these capital raising funds. So I think we are good to go to enrich our journey into the world of right issue, private placement, and preferential allotments. Over to Tejali. Thank you.
Please.
Sudhagar, please. You are on mute, Sudhagar. Sudhagar, you are on mute.
Sorry. Namaste and good morning, everyone. Welcome to a very crucial and important, very critical, not crucial, very critical and important section, that is section 42. Apart from that, section 62 is also there. In fact, I used to say always that section 42, one of us know, but of course, Kinjal is going to give you more insight into that. But Sahara scam, which we know that they have almost mobilized 45,000 crores without filing a single paper with SEBI. Subsequently, it has come to the limelight and all rest is history. I used to say always in the Companies Act 2013, there were three major scams which have taken place: Satyam, Sahara, and Sharda chit funds case. On the lighter side, I used to call them as Satyam, Shivam, Sundaram. So the Sahara is the what's called as in contributed for the stringency in the provisions of Section 42 as well as the rules thereof. In fact, this particular section as the rules have been rehashed in the year 2018, if I am not wrong, and that was the second amendment and effective from August 2018. In fact, prior to that, the section as well as the rules were for
Some disturbance is
non-compliance.
there.
Even the penal provisions initially was that the amount involved or three times the amount, whichever is higher. Subsequently, the same thing have been amended and it has been brought, whichever is lower now. So, in fact, and I really surprised that if I am not wrong, there is one more section where the promoter is also held responsible, but this is the primary section where the especially in case of big corporates, private placements used to take place left, right, and center, and any kind of non-compliance put the promoters also in trouble. Another peculiarity in this section is that unless until you file the return of allotment with the ROC, which is to be filed within 15 days, as against normally it's the 30 days, and unless until you file the return of allotment, you cannot use the funds. This is another peculiarity of this particular section. There are lot many things like this. Of course, though I used to say that no management will allow you to enjoy that what's called freedom of 15 days, because the CFO will be on your head. And not only day one, the hour one, the moment the allotment takes place, you will ensure that task 3 is filed with the ROC so that he can utilize the funds. So apart from this thing, there are not many things like this. And while Kinjali is making her presentation, we can discuss it further. So I'll give a pause here and request Bala to take over.
Good morning to all of you. I have a great pleasure in welcoming you all for today's morning session. Dipti always used to say, we will start the session once it's reached a century. Dipti, for your information, we are already in twice a century. So that shows the importance of this particular section. We have been conducting this masterclass series of the company side. The very first session, we started with actually definition. In fact, Sudhakar was also talking when we are talking about the definition. Many people think what is there in the definition, etc. If you recall, when we discussed the definition, a lot of terms we have discussed, that definition plays a very important role when we talk about section 62 and 42, especially with the reference to securities. What is security specified under section 62? What is securities under 42? Makes a hell of a lot of difference here. That is one thing. And second thing is that even section 62 and section 42 is not an independent itself. It has to be read in conjunction. Because when we are actually acting on section 62, nevertheless, there are compliances which are required to be complied under section 42 is also required to be complied with that. So as Sudhakar and our Rajiv Malik puts earlier, there are a lot of intricacies which are actually there on section 42 and section 62. And especially when the money is to be used, what is to be done. And many people in the business people, they don't allow you don't get the time. All those things are all there. Again, the filing of the form PAS3, which is very important. In fact, I have come across many cases. The PAS3 has been filed in a hurriedly and ultimately there has been some mistakes. Even the company and also the practicing company secretary, they have been penalized for filing the wrong PAS3 certification, etc. All these intricacies which are actually involved. In fact, Kenjal is actually going to take us through all the intricacies. And we have the benefit of Rajiv Malik. He will be actually sharing with us his practical experience and insight out of it. And as he mentioned in the beginning only about the Sahara case, which is actually gave way to section 42 introduction in the Companies Act 2013, which was not the case in 1956, we'll be able to hear from him. With this, I'll pass on the session to Kinjal. Kinjal, it is all for you. Please take us over.
I'll welcome our other partner, Ms. Aditi and Alifia also, and Ms. Pooja and Channa. Thank you. Yeah, Kinjal, take it.
Good morning, everyone. A warm welcome from Mehta and Mehta. So today's theme is an insight into the issue of securities on rights and private placement basis and preferential allotments. Let's do the deep diving. This is the theme for the presentation for today. We'll discuss about the medium or the modes of raising the share capital as mentioned in the section 23. Then we'll move on to the section 42. We'll talk about the origination and the genesis for this section, that is the analysis. We'll discuss about the process flow. From there, we move on to the section 62 for the rights issue. We'll take up the analysis for the section 62, then the process flow for the issuance of shares on rights basis, and then we discuss the preferential allotments. Modes of raising the share capital. Now, this is a new section which has been added in Companies Act 2013. It defines the ways how the public or the private company may issue the securities and raise the capital. So for the public company, three ways have been stated. That is a public issue, then the second is rights issue or the bonus issue, and third is private placement. For a private limited company, it is a rights issue or bonus issue, and the second is private placement mechanism. Issue of securities on private placement. It is governed by section 42. As my other panelists have just stated that the genesis for this section is lying because of the Sahara India Real Estate Corporation case. Now, Sahara Group was operating an extensive network of around 4,000 establishments under the Sahara India umbrella, and their subsidiary companies were Sahara India Real Estate Corporation and Sahara Housing Investment Corporation, which were primarily into the residential housing projects across India. 2008, RBI had imposed a ban on Sahara India Financial Corporation to prevent it from raising additional deposits. Hence, they worked out another mechanism wherein Sahara India Real Estate and Sahara Housing Investment Corporation started offering OFCDs and reaching out subscriptions from the investors. Now, this was done during the period of 2008 to 2011. So that's almost fairly a long period of 10 years, throughout which they kept on raising money through OFCD issuances. And they totally collected almost the amount of 17,000 crores. Now, what happened was later on, one of the other Sahara Group company was going in for a public issue. And in the RHP, the details of the group companies were required to come in. And that's how this whole matter started off. And it went into a regulatory investigation. The issues which were discussed during this case was the jurisdictional dispute was whether the SEBI has the right to investigate and adjudicate on this matter, considering it is an unlisted group of company under Section 11 of the SEBI Act or 55A of the Companies Act 1956. What about the OFCDs? OFCDs are securities under the definition of the SEBI Act and the SECRA regulations, but not under the Companies Act 1956. OFCDs were considered as private placement. I mean, Sahara had not reached out to public as such. Hence, was it really a private placement or was it a public issue? Then applicability of the listing regulations also came into picture, considering whether the listing regulations as mentioned in Section 73 were pertaining listing requirements for Section 73. Was it mandatory for all the public issue or was it the application depending on the intention of the company to seek a listing? Then application of the Public Unlisted Companies Preferential Allotment Rules 2003 under the Companies Act 1956. And how does OFCD get covered under this law? That was a question mark over there. Classification of the OFCD as a convertible bond and whether there is an exemption available under the SECRA regulation. These were the matter of disputes in this particular case matter. And then finally, based on the SAT judgment and even going in for the appeal, Supreme Court ruled out that, yes, it is a public issue. What was also observed by the law, by the Supreme Court was that there is a lacuna out there in terms of the Companies Act and the SEBI regulations. While SEBI regulations covered securities, Companies Act under the Unlisted Public Companies Preferential Allotment Rules did not mention securities. It covered only shares. And that's how there were a lot of malpractices. While Sahara's case was a very high profile one, there were many other instances also where private placement mechanism was misused. So these lacunas which were coming out from the 1956 Act, wherein, this definition of the shares was being considered under private placement was a very narrow one. Not all securities were getting covered, whereas the SEBI definition had all the securities covered. And the other issue was with respect to the rules that private placement can be made only to a maximum of 49 persons at one go. However, there was no provision to prevent the company from convening multiple board meetings to approve such allotments, which did happen in Sahara's case. Considering all of this thing, in Companies Act 2013, Section 42 has been introduced. So in Section 42, first of all, the definition for the definition for securities has been introduced. So when we talk about the definition for securities, it covers shares, scrips, stocks, bonds, debentures, debenture stocks, marketable securities, derivatives are included, units of the other instruments of the collective investment schemes are included, security receipts under SARFAESI Act are covered. However, units under instruments, the units under instruments for the mutual fund schemes are also covered, but ULIPs for wherein, the basic or the underlying the instrument where it is combining the benefit of a risk and the investment is not covered, which is coming from the Insurance Act. Then pooled investment vehicle instruments are covered. Certificate of the instruments issued to the investor based on the special purpose distinct entities, that is basically debts or receivables or mortgage debts, are covered. Government securities are covered. Specific delivery contracts are covered. And while we say that derivatives are covered, so what is derivative? The derivative, the definition in Companies Act refers back to the Securities Contract Regulation Act, which says derivatives basically security which is getting derived from the underlying debt instrument, shares, loans, or contracts, or the values from the prices or the index of the prices. So now what has happened is, the securities definition has been covered. What is private placement? A private placement which is made to a selected group of person and which has been identified by the board of directors, and it is called as identified persons. Now this number will never, should not exceed in aggregate in a financial year for 200. And this excludes qualified institutional buyers and the employees of the company, which are being offered securities under the scheme of employee stock option. Why do companies opt for private placement? There are advantages, there are disadvantages over there. When we say advantages, it allows raising of the capital quickly. As the panelists said, yes, you have a very quick mechanism. Go for a special resolution, go ahead with the filing of pass 3, and you're done and you utilize the money. And basically you're, cutting down timelines with respect to public offering. Then you can, raise the capital from that select group of investors who understand your business and the growth prospects. It's of course a cost-effective manner vis-a-vis the cost of raising the capital and the regulatory compliance cost which comes with a public issue. And, before going in for a public issue, the companies can actually figure out whether the outside investor, other than the promoters or the existing shareholders, how is it? They can test the waters before going for the public issue. What are the disadvantages out there? You're limiting yourself to a small group of investors. It's definitely difficult to raise large amount of capital through this mechanism. Also, finding investors who would be interested in your company's securities, who understand the business, might be a challenge out there. And it's a riskier investment for the investors also, as the securities are not publicly traded, or maybe less liquid, even though they might be private placed securities which are listed also. Still, the liquidity is still a constraint out there. I'll move on to the other slide. Now, this is just a snapshot of what is the Indian bond market right now going on. Private placement, the bond market is on a high right now. We see here one tabulated database out here, which is talking about the funds raised through the corporate bonds. It's a comparative table giving FY23-24. And as we see, FY24 mobilization of money through corporate bonds has hit all-time high, with NABARD, REC, HDFC, PFC leading the issuances, issue sizes actually. In the private sector, the financial institutions and the banks have raised most of the funds through private placement routes. That is 4.68 lakh CR with respect to, which is higher than the FY23 amount. Now, all of this factor, these numbers which are there, they are all with respect to the listed private placement or the debt private placements which are there. Whereas in the unlisted category also, we have huge, movement or the funding happening. However, that's not getting reported as such. There's one more factor in this Indian bond market is getting excited is because the Indian bond market has been included in the global indexes, and that's going to be a game changer out there. So going ahead, what we can see is that fundraising through corporate bonds mechanism, this is a report which has come. We see the 10% annualized rate in 2024-25. That is primarily because of the lower borrowing cost with the increased demand from foreign as well as domestic investors. So this was just a little, snippet on the Indian market right now. Now we move on to for the private placement process flow. Private placement process flow is governed by Section 42 and the Rules 13 of the Company's Prospectus and Allotment Securities Rules 2014. We conduct a board meeting, decide the security type and the issue size also, decide the list of the allottees. At a time, only 50 can be allotted, and in an aggregate, in a particular financial year, you cannot cross more than 200. It has to be less than 200 basically. Approve the EGM notice if required. I approve the EGM notice because you have to take the special resolution of the shareholders for that. The draft letter of offer will be in the format of Pass 4, and valuation report also has to be there, and a separate bank account has to be opened for the proposed issue of the securities. It's pertinent to note out here that MGT 14 requirement is very essential out here with the board resolution filing. We'll open a separate bank account with a scheduled bank. The money will be utilized only for the adjustment against the allotment of the security or the repayment of the money in case if the company is not able to allot the securities. We hold the EGM, pass the special resolution, approve the private placement of securities and the draft offer letter. And the MGT 14 has to be filed even for the special resolution, which is approved. Then we dispatch the Pass 4 application letter, which is there. Now, this has to be done within 30 days of passing of the resolution. It will be either in writing or in an electronic mode. Attachments are the CTC of the special resolution, the explanatory statement. The explanatory statement has certain, criteria which are stipulated, which I'm covering it in the subsequent slide. The private placement offer application shall not carry any right of renunciation. Now, this is very important. Under private placement, there is no right of renunciation if you compare it along with the rights issue. So under rights issue, the right of renunciation, it is essential part of the rights issue. Whereas in private placement, there is no right for renunciation. It has to be subscribed by the selected group of persons, identified persons which are there. And issuance of Pass 4 only after filing of MGT 14 can be done. Pass 5, we have to maintain the private placement entire offer details in the format as prescribed under Pass 5. Subscription monies, proposed allottees will subscribe to the shares in the private placement offer application along with the subscription money. Now, this will come either by check or demand draft or the other banking channel and not by cash. So this rule states that the mechanism or the medium how the subscription money will be received out here. And in case of joint holding, it will be coming from the bank account of the first holder in the application. However, this sub rule is not applicable in the case of issue of shares for consideration without cash. So it's quite pertinent to note out here that private placements can be done for consideration other than cash. What the rule specifies is the medium, how the cash will be received in case, basically how the subscription money will be received. Allotment of securities, we have to allot the securities within 60 days. Pass 3 has to be filed within 15 days from the allotment date. And if it is not able to allot the securities within that period, the company, it shall repay the application money within 15 days from the expiry of the 60 days. And if the company fails to repay the application money within this period, it shall be liable to repay that money with an interest rate at the rate of 12% per annum for the from the expiry of the 60th day. It's pertinent to note out here in the matter of Kushan Mitra versus Amit Goel 2021 NCLAT judgment. NCLAT has held that this in the event of non-allotment of the shares, this application money which has come, it is a debt. And this, you can proceed under the IBC law.
Shivakumar has put up a question. Are the private limited companies share also to be dematted if there are any exemption in the family companies?
I didn't get the question.
No, are the private limited company shares also to be dematted? That means he is talking about allotment of the share in the demat form.
Yes, the demat, yes, provisions have to be followed.
Yeah, because the private companies have been now brought in under the demat. But next question is asking, is there any exemption in family companies? There is nothing called the family companies. It is only family run, but it is a private or public, whatever it is. Once you are coming in the private company, then the demat automatically applies. There is no exemption available. Correct, no?
Yes. Dematerialization, yes, demat shares have to be there. Yes.
There is one.
So it is out here in the process flow what we're talking about. So whatever the board meeting requirements are there for conducting the board meeting, all of those compliances have to be ensured. All of those compliances with respect to holding the EGM, sending the notices within whatever the time frame of 21 days and minutes preparation, all of those compliances have to be ensured.
Just Just this is the procedural part. Another thing is when the company is looking for a private placement. So of course, there are many advantages which we have just discussed. That is offer a faster and more targeted fundraising process as compared to the IPO, right? And then the company also should take identifying the right pool of investors is also a challenge. For I think the companies should look for the aligned investors which are aligned with the growth strategy. It's not only for the capital, but the strategic alliance should also is also another part. And then another aspect is the valuation considerations. So here the when company is making the private placement, then the negotiation of fair valuation is crucial. So just want to highlight these 3 points. Please go ahead.
Agreed, agreed. So now we move on to
Somebody is actually saying small companies are exempt from the demat.
Bala, this particular webinar is on section 42 or 62, not on demat. Why we are entertaining the
I
demat
know,
question?
we should not. I think it is clear. Yeah, please go ahead. That is not the topic.
so the special resolution, there are certain criteria which are further mentioned in the rule one.
Before you go further, let me explain a few points which you have missed. In fact, they are not coming out very clearly. As far as the legalities of the private placement is concerned, the first and foremost thing is private placement is to be made a select group of people to be identified by the board of directors. Always there used to be a question that what is meant by to be identified by the board of directors. It means before you are making a private placement, you have to identify the people to whom you are making the private placement. That means you have to prepare a list of the people to whom the private placement is being made. It should be placed before the board, and it should be a part of the resolution also. It is how you have to identify the people to whom you are making the private placement. Second thing is the private placement offer letter together with the application. The private placement offer letter is to be there in the past 4. A lot of information is to be furnished in that. That together with the application, it has to be circulated or it has to be sent to the people who have been identified. And when you are sending this offer letter as well as the application form, it should be name specific. You cannot give it to everybody and anybody. You have to give it only to those people whom the board has been identified. The third point is in section 42, it's very clearly mentioned there is no renunciation right. In the initial phase, several people used to ask this question. In section 62, rights issue is there. I mean that what's called as renunciation is there. Where is the renunciation in case of private placement? The reason for that is because when you are sending the offer letter as well as the application in the name specific, people should not renounce that. That's why very clearly it has been mentioned in the section itself that there is no renunciation of the right. The fourth thing is the applicant has to make the application for subscription of the shares or for allotment of the shares together with a check or draft, whatever it is, from his own bank account, which was not, all these provisions were not there under the old act. In the old act, even in IPOs also, when you are making an application is being made by somebody, whereas the check has been attached of somebody else. Because of that, so many malpractices have taken place. And the final point is, you have to make the allotment within 60 days. And unless until you complete the allotment, you cannot open the next issue. All these are courtesy Sahara case. If anybody read the Sahara case thoroughly, you will come to know that Sahara has mobilized 45,000 crore rupees. Nothing because of that. These are all the what's called as stringent provisions which were not there under the 1956 Act. So what they used to do is whatever the money collected in a day, divide by 49. They used to say series 1, series 2, series 3 like that. They used to open n number of issues. And then they used to not making any allotment because the allotment, there is no time period under the old act. Within how many days you have to make the allotment? That is the reason actually why it has been brought in. Within 60 days, you have to make the allotment, and unless until you complete the allotment of the previous issue, you cannot open new issue also. More final point is that, as you rightly said, it is 200 people, more than 200, you cannot make the private placement in a financial year. But it was initially there 200 people, that I mean, to the people whom you have to make it. But subsequently, when this section got and the rules got rehashed in 2018, they say that this limit of 200 is to be reckoned per security. That means if you are making an equity issue, 200 people. If you are making a preference issue, another 200 people. If you are making a debenture issue, another 200 people. Like that, this 200 limit is to be reckoned security wise and not the total of the issues. Okay. Yeah. So these are the few points I thought I will bring it to the notice of the participants. And now you can take it further, Kinjal.
In addition to what you have said, there is also a provision on advertisement while doing the private placement. I think that is.
Yeah.
Please go ahead.
Sir, agreed out there. The mechanism for getting the subscription money from the bank account of the individual subscriber, in the case of joint holder, single holder, it's mentioned in this particular section very specifically. Vis-a-vis, if we compare section 62, it is not being mentioned out there. So that is a finer, nuances between these two sections as if we do the comparison thing. The other part in respect of the restriction, yes, 200 persons, and it is with respect to each of the security being issued. It is not overall person, which I'm covering in my subsequent slide. So now, when it comes to the private placement being made, it has to be approved by the special resolution. Now, certain more additional conditions which are mentioned as out here are the NCD issuances which are within the limits under section 181C with the that can be approved with relevant board resolution. So here what we are talking about special resolution requirement and where it can be lived with a board resolution thing. So that will be adequate for NCD issuances which are exceeding the limits of under section 181C. Special resolution will have to be passed only once in a year. And for the offer to the QIBs, it is sufficient if the special resolution is passed only once in a year for all the allotments to such buyers during the particular financial year. It's also important to note that if any subscriber is is an individual or a body corporate or a national of a country which is sharing land borders with India, then it is compulsory or mandatory to take the approval under the Foreign Exchange Management Non-Debt Instruments Rule 2019, and such an approval will have to be attached with the passport, which is the letter of offer. Now, what are the disclosure requirements in the explanatory statement? So particulars of the offer, including the date of the board resolution, the type of the security, the price at which it is being offered, the justification for the price, for how it is being derived, the valuer details, who has carried out the valuation, then what is the intention of the company to, for utilizing of this money which is raised, and material terms like proposed time schedule, objects, purposes of the offer, contribution being made by the promoter directors, and principal terms of the asset charge, etc. will have to come out in this explanatory statement. Company shall not utilize the money raised through it unless and until allotment is made and the return of the allotment is filed with the registrar within 15 days, which I mentioned in the earlier slide, reiterating out here. And under the prospectus, this is the dematerialization requirement, which one of the participants had asked actually. So yes, you have to issue the, securities in the dematerialized form. And if any security is there, which is in physical form, we'll have to facilitate the dematerialization of all the securities. Now, no fresh offer or an invitation can be made unless and until the allotment with respect to the offer or the invitation which has been made earlier has been completed, or either that offer or the invitation has been withdrawn or abandoned by the company. And the maximum number of identified person, that is 200, has to be maintained. And that is with respect to more than, a company may at any time make more than one issue of security to such class of identified persons as may be prescribed. Now, coming to section 42, subsection 7, it is very clearly, it is mentioned in the act itself that no company issuing this securities under the private placement mechanism will issue any sort of public advertisement, utilize any media, marketing or distribution channels or agents to inform the public at large about such an issue. Two pertinent case laws out here. In Sanjay Parmanik, the SEBI held that offer placement which has been made to more than 200 companies, then in terms of section 42, that will be considered or deemed as a public issue. And another case wherein the ROC of Delhi has levied heavy penalties on Enbronica Technologies Private Limited, which was this is with respect to the crowdfunding platform of Taike, and the company had raised money on this. Panelists would like to discuss about this. Rajiv sir?
Yeah, so these are the latest trend actually in the startups and the crowdfunding, that people are trying to avoid the investment. They're making the investment through. They are saying it is the private placement, but actually they are approaching to the public, to the third party. For example, in this case, that they have approached the Taike. This Taike platform is the online platform where although the securities are being issued to the Taike platform, and through Taike platform it has been issued to the vast public, and in fact they have channelized and advertised these things on the YouTube channel. So there's a separate company involving in the regulator clearly says that they cannot advertise in any means. So that is the crux here.
Yes, sir. So ROC came heavily on Enbronica Technologies, which used this platform, but surprisingly, Taike platform itself was not penalized actually. And even they had, they were taking subscriptions actually, and then provided the value-added services on that platform. So this is something, which is the startups have to take care in terms of the compliance requirements while raising the funds out here. So while for crowdfunding, if we see, under we have AIF regulations which govern, crowdfunding with respect to the funds which are there, or you have a mutual fund regulation which is there. However, out here, the startups have to take care and be careful with respect to their, fundraising mechanism what they're using out there. And what ROC has mentioned in this judgment is that the companies who are using such kind of platform, they have to be careful with respect to whether these platforms are actually, complying with the compliance requirements under the company law. That has also been mentioned under this order actually.
Yeah,
But there is no,
I-
no provision under Companies Act to where we can implement Taike platform.
Yeah,
of
in
now.
fact, ROC has himself mentioned in his order itself,
Yeah.
referring the same section under section 42. There is no provision under section 42 to take any action against the Taiko platform. That is the reason why he could not take any action. He himself was mentioned in the order itself, if you actually go through it.
Yes.
It was one of the very speaking order, which is running something around 16 pages or something like that, giving all the reasonings.
See, in fact, one more thing is section 42 and the rules are applicable to the companies. So in this particular case, the companies are trying to circumvent the provisions of the act
Right.
by making the issue on the Taiko platform. Whatever the platforms are there, because ROC has no jurisdiction as far as the platform is concerned, and platform has not done anything wrong. Wrong has been done by the company, and ROC rightly so he has penalized the.
So basically, there is a loophole right now.
Now we're talking about the penal provisions, subsection 9, 10, and 11. So in subsection 9, we're talking about if the company defaults in filing of the return allotment within the prescribed time period, the company, the promoters and the directors shall be liable for the penalty for 1,000 rupees for each day of the default which is there, and it will not exceed the 25 lakhs rupees. Under subsection 10, the company which makes an offer or accepts money which is in contravention, so basically which is in contravention of the section 42 provisions, or they have exceeded the 200 limit and kind of, then that entire amount which they have raised through the private placement mechanism, or 2 crore rupees, whichever is lower, that entire that will be penalized, and the company will also have to refund all the monies with the interest to the subscribers within the period of 30 days of the order imposing the penalty. So this is again, the penal provisions come heavily actually. And under subsection 11, any private placement which is not made in compliance with the regulations of 42 and which will be considered as a public offer, then SEBI will come into picture, and SEBI regulations will be applicable. In this is another case law which is a very detailed one again out here, where flouting of section 42 was done, and the regulator had come heavily on the company with respect to it. Now we'll be starting with the rights issue section. Sir, would you like to take any questions, or shall I move on?
Yeah, we can see some of the questions are there. Let us see the questions.
One more Angel.
Your voice is breaking,
Issue
sir.
of private placement of the
Your voice is breaking.
only after the board and special resolution ROC.
So may I request you to repeat, please? You were not audible.
Yeah, what I'm trying to say is, when you are sending the offer letter together with the application to the identified persons, that is to be sent only after you file the board resolution as well as the special resolution with the register of companies.
Yes, sir.
That is to be ensured.
Yeah, we have mentioned that under 179(1)(c) compliance has to be done, sir. We have mentioned.
Yeah, there's a question which is there actually. The question is, in the demat era, what is the mechanism available to check if the number of members does not exceed 200 in the private limited entity, as brokers are directly taking the recourse of the transfer without approval from the board, and also does not violate the condition of the restriction of the transfer of the shares by the private limited company?
No, if it is a private limited entity, and although that might be the shares are dematted, the control is entirely with the company. How does the broker come into picture, sir? It's not available as a public issue where brokers can deal. It's not on the trading platform.
You are right, actually. When you talk about the private limited company, it is strictly monitored with the restriction. I think the concerned company has to keep a watch on that. You are right, actually, on this. What is the difference between the private placement and the preemption? I think that you are going to discuss, I think so. Can we share the PPT? PPT is not shared, actually. In fact, we are disseminating the YouTube recorded channel, which will be available to you. Are there any example for the small company? I wrongly used the term family companies instead of the small companies. This is again regarding the demat question he is asking, I think so. For the issuance of the NCD, whether valuation is required.
Yeah, so we covered that in the slide, no?
Okay.
Yeah.
Whether
one.
Whether GNL 2 is required to be filed for private placement. I'm also not very clear. GNL 2 comes where?
I don't think so. That comes into this process actually.
Yeah, that's all. GNL 2 is no relevance, I think so. Can outstanding EC be converted into optionally convertible preferred share under section 62(3)? 62(3) anyway, you are going to discuss. When we discuss 62(3), we can talk about it. Can you elaborate the valuation report for the private placement?
So we'll park this question.
Okay. Is the limit of 200 in both type of companies, private or public? Yeah, 200 is the limit. As Sudhakar puts it very clearly, it is in respect of the security. Okay. We need to file MGT 14 for offer and issue allotment. Do we need to wait for the MGT 14 to be approved, or we can open the offer even if the MGT 14 form is still under process?
That's all STP filing. So there is no question about waiting for the approval actually.
I think according to me, once we file the MGT 14 form, then I think you can actually proceed with that. I think there is no question of waiting approval and all those things. Here we are only supposed to file the form and then proceed, I think so, if I'm not mistaken. Raji, would you like to add something?
I just want to add that there is one recent case which we were discussing previously, that the Planify case, where the Planify has issued to the platform and to issue to the 76 investors, right? And it's a recent, I think, 3rd April order where ROC has mentioned, and which, although the company pleaded that they are not they are doing it privately, but ROC has come very heavily on that. I think from the 1 crore share issue, the 7 crore penalty was levied. So this is a critical case where the compliance has to be met, especially for the EC, for this equity crowdfunding. Yes.
In fact, what you say is the Clarify case, what the company has done, they actually ultimately issued more number of the people specified what is under the law. But however, they created intermediately one body corporate in between, and they kept the minimum to that body corporate. Through that body corporate, they exceeded the number. They flouted the law actually. On that, the people have come heavily. Not only that, in this particular case, even the independent director and the non-executive director, they were also actually penalized heavily to the tune of about 1 crore rupees, I think so.
Right. So
because this order itself is also a speaking order, he has actually given. Although the independent director, non-executive director, it has the immunity under the act. But here, if it is done with their convenience, with their knowledge, then it is there, and he has quoted that also. That is what he has done in this particular case.
Because the directors are the promoters of the both companies, actually.
Yeah.
And they have clearly violated 42(7).
Correct. You are absolutely right. Then the rest of the questions are only DMAT, which we said is not relevant here. Then 62 questions, I think she is going to discuss. What are the consequences if the company is not able to repay the excess share application money?
How is it pertinent excess share application money? The question is not understood.
I also got a doubt same. I don't know what Sachin, can you elaborate on that? Your question is not very clear to us. I think that is all the question pertaining to this. I think you can move forward, Kinjal.
Okay. So now we start with section 62, pertains to rights issue of the shares. Again, the same thing, we'll talk about the, what is rights issue, then how is the process flow, certain analysis of section 62 vis-a-vis Companies Act 1956 and all, and then preferential allotments. Now, what is the rights issue? It's a graphic representation out here. So company is there, it offers shares to its existing shareholders. They decide to buy these shares and these additional shares, and they pay this amount to the company. So this is another mechanism of raising the capital. Now we mentioned out here that the shares are offered at a discounted price. I'll just give a disclaimer. This is with respect to, so when we say listed entities, if the current market price for a listed entity is say something like 500 rupees, the trading price which is there, no shareholder will buy the rights issued share at the same price. So it is discounted price with respect to the trading price of the listed entities shares which are there. And if it is an unlisted group of company, unlisted entity, then the issue of the shares will have to be at par or at premium. Typically, the rights issue happens in the ratio. It is spelled out. So you have like 1:3. So for like every 3 shares held, say 1 share is given to the shareholder, the existing shareholder. The shareholder subscribes to the rights issue and makes the payment. So the benefit for the shareholder is that he is getting the share at a little lesser price as compared to the current market price at which the share of the company is being traded on the platform. And they can participate, they can, which otherwise if they go in the regular secondary stock exchange market, they will have to pay higher amount out there. What is the reason? Why are the rights issue being used? For capital expansion, for debt reduction, like in the case of Tata Motors, once they acquired Jaguar Land Rover brands or Tata Steel for the Chorus deal, post that, with respect to their financing arrangements, they all had come out with the rights issue. So debt reduction is another intention for raising funds to rights issue. For strategic investments, so now the company is available, but they want to go in for expansion mode, they want to acquire companies. So for that, for working capital requirements also, rights issue is being done. Then there is shareholders dilution management and for an improved debt equity ratio. So what happens is that with the rights issue coming into picture, the number of shareholders increases, the shares increases. So your debt equity ratio improves by that. And even the EPS is getting impacted with that. So that is with respect to the rights issue. A very important feature of rights issue is that the right of renunciation is available out here. So if a particular shareholder is there, he does not want to subscribe to this rights issue, the rights shares which are offered, he has a right to renounce it in favor of some other person who need not be a shareholder. With this introduction of the rights issue, I would like to move on to the process flow requirement. The process flow as such is pretty simple. We draft the letter of offer, prepare the list of the existing shareholders. So you take a cutoff date and you decide what is the the number of shareholders whom we will be offering the shares on rights issue basis. We will hold the board meeting. In case if your authorized capital is not, having a limit over there, it is not capturing it. In that case, you will have to increase the authorized share capital also. For that requirement, you will have to go in for an EGM, have a board resolution passed for the rights issue of the shares, approve the offer letter, fix the record date, price of the equity share, and the ratio for the rights issue. Filing of MGT 14 comes into picture. Hold the EGM. And for the increase of the authorized share capital, file form SF7. So while we have mentioned this in a very, consolidated or very consolidated manner, but the requirements of the board meeting compliances, holding the EGM, all have to be carried out. Then the dispatch of the letter of offer happens. That has to be 3 days prior to the opening of the issue. Now this is the first time, visible if we compare with section 81 of the Companies Act 1956, here it is being mentioned that the letter of offer will be dispatched through a registered post or a speed post or an electronic mode or a courier having mode of proof of delivery, to the existing shareholders. The offer will be open. It will be open for a minimum 7 days and the maximum 30 days period has been given over there for the rights offer to remain open. Once the offer is closed, subscription is done. Conduct the board meeting, ascertain the number of shares to be allotted, allotment of the shares have to be done, issuing of the share certificate. Again, the dematerialization requirements have to be taken care. So your securities will be issued in the demat form, and the entry has to be made in the register of members, and the authority also will be given in case the share certificates are there. Pass 3 will be filed within 30 days of the allotment of the security. In case if you have foreign shareholding, that goes even in the case of private placement. FCGPR filing has to be done with the RBI within 13 days. RBI in the sense with the AD banker within 30 days of the allotment of the securities. And so share certificates will be issued and the registers have to be updated. So this was the process flow for the rights issue. As I said, renunciation of the right shares. Now, this is coming from the section 62, where unless the articles of the companies provide so, otherwise it is deemed that there is a right exercisable by the person to renounce the shares offered to him in favor of any other person. So that person need not be a shareholder. It can be any other person referred out here. And this particular renunciation right has to be mentioned in the offer letter and the notice also. So now in case of renunciation, what is the process flow? So for the shareholder, action required to be taken up is fill up the renunciation form in the favor of any other person, and a shareholder will be able to renounce. Part renunciation is also allowable. So say post based on the ratio which is there for the rights issue being right shares being offered, if the person is eligible to say 100 shares, he may renounce part shares. So like 50 shares he can renounce in somebody else in favor of somebody some other person, and 50 shares he will subscribe to that extent. The action required to be taken care by the company is the receipt of the application money and the acceptance form from the renouncing, and then the allotment of shares to the renouncing. So that is with respect to the renunciation of the shares. Two case laws out here, R. Khemka versus Deccan Enterprises. It's a 98 judgment by the Andhra High Court. It is the judgment says that if the member or a shareholder has not responded to the offers, it means that he is not inclined to subscribe to the additional shares offered to him, and thereby it is an implied consent for the allotment of the shares to the others. And in Madhusudanam versus Kerala Kaumudi case 2003 judgment, Supreme Court held that if the shareholders are not given the notice to apply for the allotment of the shares, then subsequent allotment to others is invalid. We move on to the other slide. Now, treatment of unsubscribed shares. Section 62, subsection 1A3. Now, this is a changed subsection vis-a-vis section 81 1D of the Companies Act 1956. Under Companies Act 1956, the unsubscribed portion of the rights issue could be dealt by the board in such manner as they think most beneficial to the company. Now, under section 62, they have introduced is that after the expiry of the time period, whatever the unsubscribed shares are there, the board may dispose them off in such a manner which is not disadvantageous to the shareholders and the company. So if we compare these two subsections, the term in such manner as I think most beneficial is a very wide term under section 81 of the Companies Act 1956. And whereas under section 62, it is a more practical approach and a more narrowed down approach which has been taken. And it is good actually, because even in Mafatlal's landmark judgment, it was mentioned that under section 81, it is a very, very wide term to determine whether how it will be beneficial to the company in case if the unsubscribed portion is being, because the board has been authorized for dealing with it. Now, two questions out here: applicability of section 42 and applicability of part 1 of chapter 3 of public issue. I would request the panelists to give their thoughts on this action.
Mr. Rajiv, you would like to say? I think you can go ahead.
Either you meant to say preferential allotment and private placement, or what you're asking?
So what happens is that you see the shares will be allocated, the unsubscribed portion will be given to the non-shareholders actually. So are we going to take care in terms of section 42? And what happens, especially in the case of large unlisted public companies, so they might be having 200 shareholders.
Unsubscribed portion, when you are giving it to, when your board is disposing it off, that has nothing to do with section 42. Okay. So only thing is, whatever the unsubscribed portion, the board of the requirement is, it should be for the benefit of the company.
Right.
That means what?
So,
because whenever they are making this allotment to the other to whoever are the other people, most of the times what happens is, in case of rights issue, people apply for additional shares also. So it is the responsibility of the board to ensure that in which ratio they want to give it to the people who have applied for the additional shares. Suppose it may so happen, people have not applied for the additional shares, they are not subscribed for the right shares, and some shares are left over. In such case, what happens? Okay, the board if anybody, the board can dispose it off in any other way means, it can give it to the promoter. Suppose the promoter may put an application, it can be given to the promoters, or alternately, they may even cancel the shares, whatever they are left out. See, because if it is unsubscribed, means what? The shareholder has no confidence in the company. So that point of time, the promoter may come and he may pick it up, or alternately, the board may decide even to cancel the shares also. Only thing what they say is when it is benefit to the company, the promoters should not corner the, the board should not corner the shares in collusion with the promoter or anybody else. They should be fair and transparent manner that disposal should take place. Yeah.
Yeah, Raji wanted to say something.
Yeah, I was just like saying same thing that the Section 62 of the Act has not imposed any restrictions on the board discretion in allotting the unsubscribed shares, right shares to a non-shareholder, so long as it can actually demonstrate that such allotments is not disadvantage to the company and its shareholders. So, if we are taking a view that such allotment of unsubscribed shares to non-shareholders would tantamount to private placement, right, then under Section 42 Act, then it would render the said provision almost unworkable, as the company cannot change its course midway to comply with several other requirements of Section 42 and the PA's rules. So nothing in the scheme of Section 62 suggests taking such a view actually. So, however, companies would have definitely have to comply with the other rules for any subscription of the by the non-resident, etc. Right, and also it needs to ensure that the number of non-shareholder subscription in such category does not exceed 200. So, board discretion in this regard, I think, remains the unfettered here. Yeah.
Yes. In fact, the company can also take, in this particular case, they can allot the shares even to the in other investors who are actually interested in the, in the growth and the prospects of the company. That can also be worked out. That is also advantageous if they bring in that expertise in.
In fact, most of the times, the articles of association of the company also prescribes a procedure about the rights issue and the unsubscribed portion, how the board has to dispose it off. It is always
agreed.
advisable to have that thing, and that time the company has to comply with whatever the provisions are there in the articles of association.
This is very good advice you have given, because that will help the board any question in future for their action or as such. Right. Yeah, Pinja.
Shall I move on to the other slide?
Yeah, please.
Now, section 62, subsection 3. Now, this talks about, increase in the subscribed capital caused by the excesses of option. Basically, the debenture or the loans which have been issued, and the capital increase which is coming into picture post conversion of such debentures or loans. So this section pertains to that. It's very important to quote out here this case, the Kenning Industries Cochin versus SEBI 2020 judgment, which is there. Now, this particular case, what had happened was Kenning Industries had come out with, debentures, convertible debentures, which were there. And lot of interpretation has gone in terms of the provisions of section 42 and 62 with respect to this conversion of the debentures, and then whatever the unsubscribed part, the debenture conversion, and post that the unsubscribed part of the shares which was there, the allotment of that, and other aspects have been covered under this judgment. So the tribunal has stated that the company, they have to comply with the 62 subsection 3 requirement, and conversion rules for the debenture rules will have to be also complied along with it. We move on to the preferential allotments requirement. Prior to that, Bala sir, would you like to take any questions?
Yeah, we will do that. Either any restriction for the right ratio, can the company issue 15 shares for 1 share held?
It is completely the discretion of the board to decide this, the issue in case of rights.
Can you issue preference share on right issue basis?
Yes, certainly.
In case of the right issue, filing in form MGT 14 is a mandatory one.
All forms related, we will take it later, Mr. Bala.
Okay,
And others thing you take.
okay. Can a private company have a lesser time period than the 7 days for the right issue offer?
Yeah, I say that it says 90% of the shareholders consent if it is there. It can be less than 7 days also.
Does private placement require shareholders approval?
Certainly, Section 42 requires that. A special resolution is required. Rights issue, it doesn't require shareholder approval. That is only for board approval is required. But as far as the private placement is concerned, certainly it requires shareholders approval by way of a special resolution.
I don't know whether this question is relevant or not. If shares are not in the demat form, can we not use right entitlement and not renounce the same?
See, rights entitlement is only in case of listed companies. That also under the SEBI regulation, ICDR regulations. Rights entitlement is not there in the term is not there in the Companies Act.
In case of the issue of the preference share, can we issue share on the right basis initially to the existing shareholder and all the shareholders want to renounce? So can renounce share to the reason who are not shareholders at the time of the issue?
Yeah, it is possible. It can be done. Technically, it can be done.
Not benefit to the company, rather not a disadvantage to the shareholders and the company. Can you throw some light on this?
We discussed already this.
Valuation report from the register is required for under section 62(3).
Yes, preferential allotment valuation report is required.
Whether can we make a share multiple allotment as and when money received during the period open?
You have to close the offer, then only the allotment can take place.
On right issue before allotment of share, can the fund be utilized for business purposes? I think this we discuss elaborately.
There is no restriction on,
Can preference share and
but not advisable. There is no restriction as such. In case of rights issue, you cannot use the money. That kind of restriction is not there. But sometimes a question comes that shareholder can withdraw his application before making the allotment. But again, there are different views are there. In case of a rights issue, once you make the application, you cannot withdraw that. There is case of public issue, the shareholder can withdraw the application before the allotment. So, which is not the case in case of a rights issue. There is a difference between public and rights issue.
Can the preference share and debenture be allotted on right basis?
See, though technically that section 62 talks about rights, issue of shares on rights basis. They are not talked about issue of securities as such. But 62(3), if I am not wrong, it talks about issue of securities on preferential basis. Okay. So, whether debentures you will give on a rights basis, there is no prohibition as such. Because of that, I can say that I can issue even debentures also on rights basis, especially in case of convertible debentures.
What is the requirement of DI filing and DPIIT filing in case of the major shareholder is being a foreign entity or stroke foreign fund?
FEMA compliances have to be taken.
FEMA compliances will be called for. Can an unsecured loan be converted into the OCD, CCD as per the section 62(3) of the Companies Act?
It depends when you are issuing, when you are passing the, when you are issuing the OCDs and CCDs, that point of time, you have to have the shareholders' approval. When that loan, when before accepting the loan, there should be a conversion clause and that is to be approved by the shareholders, then it can be done.
How many right issues can be made in a year?
As many as you feel like. But only thing what you have to ensure is that to ensure your previous allotment is complete, then you go ahead with it.
The renounced share can be acquired by the promoter in case of the listed company. Mayur is asking this question. Renounced share can be acquired by the promoter in case of a listed company.
Yes, why not? See, suppose if any shareholder is renouncing his shares to the promoter, there is no prohibition. Promoter can acquire that.
Only thing that promoters shares quota and all that other applicable provision you have to take care.
See, somebody put a question that section 55 requires a special resolution, but section 62 requires a board resolution. Different shares on right basis, no doubt about it. I said that yes, it can be done. But definitely when you are issuing preference shares or debentures and all, you have to comply with other sections wherever it is applicable. When you say on rights basis means what? It is a firm allotment to the existing shareholders. That's what my meaning to say. No doubt about it, you have to complete section 55 for issue of preference shares, whatever the procedure is there. Same is the case with the debentures also. When you are issuing debentures, if I am not wrong, I think section 72, I mean, I'm not very, I mean, offhand, I don't remember the section, but that section you have to comply with. Only question, my this thing is, can I say on rights basis? Answer is yes, I can say that.
Conversion of the loan to the allotment of the share. In this case also valuation report is required.
I think if I'm not wrong, valuation report is required only in case of preferential basis, preferential allotment. But in case of conversion of the loans, how you will arrive, I think there is no specific requirement as such, but the Kinjal, because you are making the presentation, valuation report is required in case of conversion of loans into shares. But one thing
No,
I
sir.
remember, I know that very well. Yeah, you can decide the price at the time of accepting the loan itself, or you can also decide that you will arrive at the pricing before conversion of the loans into the equity. So not necessarily you have to decide that price at the which you will convert the loans into shares. You have to decide in the first place. That requirement is not there. But to my knowledge, I don't require valuation report, if I am not wrong.
Yeah, I agree with you, Sudhagar.
Kinjal, correct me
Valuation will not be
if
required.
I am wrong.
Yeah, valuation will not be required.
Correct.
No, sir, agreed with you. Loan conversion valuation requirement is not there actually.
Yeah.
It is only in the primary place of taking the loan or availing the loan. That time only you put in that clause that what will be the pricing mechanism.
Correct. You are right. Absolutely, you are right. Can a company issue an offer made for a bigger number of the shares and allot shares in tranches upon decision from time to time, at least in 3 stages, providing that the right to subscribe to the shareholder to whom the issue of the share preferential basis is made?
Yeah, that can be done. You can say shareholders can pass an umbrella resolution for issue of securities. Then they can delegate that power to the board. But that doesn't mean that the duration should not be, I mean, though it is not clearly mandated as such, the validity of the shareholders resolution, it should not happen that at the umbrella resolution, the board is taking for a huge amount and for years together, they are issuing the shares without further approval of shareholder. That should not be done. So don't what's called make a mockery of the provisions, but yes, in a financial year, suppose if you want to issue the shares in a one or more tranches, you can take the shareholders approval by an umbrella resolution, and you can issue and allot the shares in one or more tranches also.
Valuation of the share.
My advice is don't go beyond 1 year.
Valuations of share may be carried out by a registered valuer of this or a CA with 10 years of the experience. The acceptable
Yes.
method of the valuation may be indicated.
He's telling that you can skip that. He is just telling who can do
Okay.
valuation.
See, I can answer anyway that, see, valuation is concerned. Earlier, it was there by a registered valuer. But when the registered valuers were not ready, they have, for a short-term purpose, they have given that authority to a merchant banker can value the shares. But now the registered valuers are there in place. You have to go to the registered value. Chartered accountant cannot do that.
Whether unsecured OCD can be done. I don't know what is the question here.
Yes, it can be unsecured optionally convertible debentures.
Okay.
So you don't need to issue the debentures, only secured debentures you have to issue. That mandate is not there. So optionally convertible debentures which are unsecured, you can do it, no issue.
Funds are invariably used by the promoters immediately on receipt of the same from abroad. It is precondition that without filing the form with the ROC, no fund may be made use of it. I think we talked to this on this.
If it is a private placement, the promoter is not supposed to use the money. And second thing is, promoters can never use it. It is only the company can use the money.
If promoter group can acquire the renounced rights share, then any limit in terms of percentage of the holding share in case of the listed company. Yeah, that public holding limited will be there. That is applicable, I think so.
Yeah, you see takeover regulations.
Yeah.
2%, 5% limits are there.
Yeah. Can forfeited share allotted to the promoter in case of the listed company?
See, most of the times in case of forfeited shares, articles of association has to how the shares can be reissued. And I think that Companies Act prohibits that you
Again, there's a problem on the voice. I think Sudhakar, you have to.
Now?
Yeah, now it's okay.
See, what I'm trying to say is forfeiture of shares is a very sensitive matter. Elaborate procedure normally used to be given in the articles. So forfeit the shares accordingly, and then reissue mechanism also is given in the articles itself. This way. According to me, no forfeited shares cannot be issued to the promoters. But only thing is, promoters should not corner those shares. Those are to be issued to everyone in a fair and transparent manner.
Can right issue is the method for loan conversion?
It can't be because the local is different and right issue is different entirely.
While issued debenture, no conversion term was there. Now the company and the lender want to change the terms to make it CCD. In this case, while changing the terms, whether valuation and shareholders approval is required. If yes, at the time of the conversion, one more time shareholder approval is required, as the section says, at the time of raising the debt capital, conversion terms be there, whereas the above example, conversion terms were inserted during the investment period.
Yes, it will have to be.
Conversion of the loan, it is very clear. You have to have the conversion terms before you accept the loan. You cannot do that thing in between.
While getting the loan option was not given, can it provide option now since the company has insufficient fund?
That's what we are discussing just now.
I am finding it difficult to file PAS3 is the purpose. They are asking valuation reports.
See, if it is valuation report is required, means what? If it is a preferential allotment, obviously you should have filed that valuation report. If it is not a preferential allotment, then nobody will ask you for the valuation report. If it is a mere rights issue.
I think conversion of the loan into the equity capital requires valuation report to arrive the price per share. Somebody has put a.
We discussed already this thing.
Is the information memorandum for circulation of the intending investor, is there any pro forma prescribed, or one could make its own detailing about the company and its past performance, etc.?
PAS 4. PAS 4 is prescribed for private placement information memorandum.
Companies issuing shares in the tranches on the provisional basis. So do we have to get valuation report every time we allot?
Yes, preferential allotment, you have to have for every tranche when you are arriving at the pricing mechanism, that point of time you require valuation report.
Can we issue fresh preference share allotment through the right issue to existing shareholder, renounce rights and issue new shareholders? Loan conversion, I think we talked about it. Can we come out with the IPO where 100% promoter equity is for share issued for other than cash?
Why not? Once you allot the shares, the color is same, whether you issue for cash or for consideration other than the cash.
Valuation report date in case of the private placement and validity of valuation report in the private placement.
It should be prior to the issue of your offer memorandum. And private placement, if I am not wrong, valuation is not, report is not mandatory for private placement. It is only for preferential allotment, it is mandatory.
Unsecured OCDs, are they not considered as the deposits?
If you again see, this is a question of controversial. If you are accepting from individuals, yes, definitely. If it is from corporate to corporate, it is an exempted deposit.
Somebody actually put here.
But there are different school of thoughts are there. Some people say that in the serial order you have to take it. Some people say no, it is not so. But I belong to the school where it says that corporate to corporate, it is not a fixed deposit. It is an exempted deposit.
Somebody has put up here, unsecured optional conversion would be a deposit under deposit rules. Only CCD up to 10 years turnover and exempted from the deposit rules.
See, this is what I'm mentioning. If unsecured deposit, if you are accepting from individuals, no doubt, or anything other than the corporate or a company, let me put it this way, then it may fall into. But if it is from a company to company, even unsecured deposit also, it is not a deposit because it falls under the exempted deposit rules. Okay. As far as the other than the company is concerned, you need to examine that whether it is a partnership form, whether it is HUF, society, there may be so many other modes. You have to see that.
Can loan be converted to the share if there is no prior condition passed for the same earlier?
We have discussed it already.
Even this is not clearly cleared by the SEBI official. Basically, 20% of the post-issue capital has to be for cash and is locked for about 3 years.
That is ICDR guidelines entirely. You have to see the ICDR guidelines if your company is a listed company and whatever the regulatory requirements are there, you need to comply with that. Under the company side, there is no such requirement.
Whether unsecured OCD treat as an exempted deposit.
We discussed already.
Somebody is asking, sir, it means debenture cannot be issued on the right basis, but convertible debenture can be issued on the right basis. Is it correct?
See, I never said that you cannot issue debentures on rights basis. There is no prohibition as such. So you have to comply with issue of debenture. That provisions you have to comply with. And after that, you can say on the rights issue, you are issuing the debentures on rights basis. With the rights basis, you are saying that in proportion of you are offering that to the existing shareholders. in a particular proportion you are giving it, that is the rights basis. So you don't need to give it also, because if it is not a convertible debenture, then there is no problem. But if it is a convertible debentures, then there is an issue. If convertible debentures you are issuing to outsiders, then there will be a different color. If the convertible debentures you are issuing on rights basis to the existing shareholders, then it will be different. So you have to see that, okay, what sort of say instrument you are giving it to the your shareholders or whoever it may be.
Can company issue more share than the right entitlement of the shareholders has applied for additional share? I think this you discuss, I think.
Yeah.
In right issue, should the ESOP holders be allotted along with the shareholders?
These are two separate issues. Rights issue is separate, ESOP is separate. Rights issue applications are different to that of ESOP applications. Rights issue allotment is different to that of ESOP allotments. So they can go simultaneously. There is no issue on that.
Do we require
And you have
valuation?
to file, and you have to file. I think, I don't know whether for one issue, I mean, two allotments, you can file one form itself or not. I'm not very sure about form filing. That is to be seen.
Do we require valuation report for ESOP?
Not required.
Preferential allotment can be made to any person or only the existing shareholders only?
Preferential allotment can be made to anyone.
In case of the
If I am not wrong, if you are making preferential allotment to the existing shareholders, that means not to everybody, but some of the existing shareholders, there are certain exemptions are there from the applicability of 42 provisions. I think 42, I think rule 1 and sub-rule 1, sub-rule 3, something like that is not applicable.
In case of the private placement, the requirement of the separate bank account is required. So if the company already have a bank account, is there some minimum balance in that account? So the company can withdraw the same for the purpose of using the bank account in private placement, or the company can use the bank account with the balance already lying in that account.
If you see the words used in section 42 and the rules thereof is a separate bank account. So this should be an exclusive, a bank account should be opened for the purpose of this particular private placement.
Yeah.
Once the private placement, once the allotment is over, and that bank account is empty, can it be used for any purpose? There is no restriction on that.
I think what you are saying is correct. A separate bank account has to be opened, I think so. Can we allot share in case of the private placement before actually the offer period ends? Generally, there is no period specified in the opening or offer period in the private placement. I think we'll go ahead with the presentation. That's what I think so.
Yes.
Until you move forward.
Yeah. Yes, so we move on to the preferential allotments. Now this is preferential allotment. This word has not been mentioned in section 62 as such. It is coming in the rules, the reference, that issue of shares on preferential basis, rule number 13, which is there on the company share capital and debentures rule 2014. So for the purpose of the section 62 subsection 1 subclause C, authorization by the special resolution passed in the general meeting, shares may be issued by the company in any manner by way of preferential offer to any person, whether or not they are covered under the clauses A and B. So clauses A and B of section 62 subsection 1 talks about the shareholders and then the ESOPs which are there, basically the employees. So other than that, any other set of persons, they are covered over here, and that is why it is the preferential offer which it is described out here. If we go to the explanation for in this clause, it says that the preferential offer, it means the issue of securities or the shares by a company to any select person or a group of persons on a preferential basis. And it does not include shares or other securities offered through a public issue, rights issue, ESOP schemes, employee stock purchase scheme, or any issue of sweat equity shares or bonus shares or depository receipts. So it's an exclusive definition as we read it out here. Also, the explanation states about that the shares of the securities referred in this explanation clause 1, it means the equity shares, FCDs, partly convertible debentures or any other securities which would be convertible into or exchanged with equity shares at a later date. Now, this rule states that the preferential allotments will have to comply with the Section 42 requirement. So what we see out here is reading all of these clauses together. Number one, our observation is that the compliance with Section 42 is required. Number two, the term shares or securities. Now here they have given the expression which is a little narrow approach as compared to Section 42 term of securities, which is a little more wider. The subsequent subclauses with the subsequent rule talks about the disclosure requirements in the explanatory statement, which is a very exhaustive list in terms of the disclosure which are required to be done in the explanatory statement. The authorized capital increase, authorization by the articles of association. Yes, a preferential allotment has to be mentioned or authorized coming from the articles of association. That is one of the criterias is there. The detail, the pre-post listing of the pre and the post shareholding patterns with respect to preferential allotments, the valuation requirement, all of these disclosures have to be mentioned in the explanatory statement. Then the sub-rule number E talks about the allotment of these securities, which has to be completed within a period of 12 months from the date of passing of the special resolution. And subclause subrule F defines that the allotment of securities, if it is not completed within the 12 months from the date of passing the special resolution, another special resolution shall be passed for the company to complete such an allotment thereafter. So when we read all of this combined, what we find is that only upon the if we have received the application money within the 12 months, then the company is obliged to allot the securities within 60 days from the date of the receipt. In case if there is no, in case of non-allotment, it has to be refunded. The application money has to be refunded within 15 days from the expiry of the above mentioned limit, and a penalty of 12% per annum interest rate will have to be paid by the company. In the subrule G, the pricing of the security that can be either in the pricing will be done in cash or for consideration other than cash shall be determined on the basis of the valuation report of the RB. And subclause H talks about convertible securities. Now, the valuation requirement with respect to the convertible securities, it's been discussed in the subrule H. So, wherever the convertible securities are there, either you decide the pricing, the valuation at the time of upfront, allotment time, when these convertible securities are being offered on the basis of the valuation report, or the time which shall not be lesser than the 30 days to the date when the holder of the convertible security becomes entitled to apply for the shares. So you have two time period out here. Either you do it upfront at the time when you're issuing the convertible security, or at the later date when the conversion time period kicks off. The disclosure has to be made adequately in the offer document with respect to the valuation and the offer of convertible security. And if the shares or the other securities are allotted for consideration other than cash, then the valuation of such consideration shall also be done by the registered valuer, who will submit a valuation report to the company giving the justification for the valuation. Our observations while reading these clauses is that the rule, the price of the shares for the securities issued under 62(1)(c) that has to be determined on the basis of the valuation report made by the registered valuer prior to the circulation of the offer letter. And on the other hand, a valuation report is not required in the case of shares under rights issue and compulsorily redeemable securities. For the preferential offer of the shares which are being made for non-cash consideration, the treatment will have to be followed, which is spelled out in the rules with respect to the non-cash consideration, that it will, if it is taking a depreciable form or amortization form, then accordingly the balance sheet will have to be done as per the accounting standards. Or if the particular clause is not applicable, in that case the index is applicable. So that was the last slide. And with this, we are closing on to the preferential allotment in today's presentation.
Thank you, Kinjal. Excellent. I think you have brought out all the aspects related to 42, 62, etc. Now we'll take the remaining question. Can we issue debenture on the right issue basis existing shareholder? That you have answered, I think. Valuation report required in case of sweat equity share or private placement.
We will discuss this when we are talking about sweat equity shares.
Okay. Somebody has given the appreciation to Sudhakar sir in the line with Raji, what he said. He is saying that I think coming from Rajesh Thakur. He says Sudhakar sir, always the same. I know him since 2004. Excellent knowledge and great person. Heads up to you, Sudhakar.
Thank you.
Question is, for preferential allotment, shares and security definition does cover preference share. Is it mandatory? Preference share can be issued only under section 42.
See, preference shares can be issued under the public issue also. So if any preference shares you are issuing under public issue method, then 42 is not a.
Do we have any guideline rule provision determining the criteria of making preference to issue shares to Mr. A or B, etc. in case of the preferential allotment?
Okay, see, Bala, am I audible now?
Yeah, very much.
Yeah, okay. So preferential allotment is basically, it can be done to other than the existing shareholders. That is what is preferential allotment. It may be to the promoters, maybe to the existing shareholders, some of them, maybe to outsiders also. That is called as preferential allotment, and whatever the provisions are there, you have to comply with that.
Do we have any guideline rules provision for determining the criteria for making the preferences?
It is the discretion of the board.
Okay. Whether preferential allotment of the existing shareholder require filing PAS 4. I think PAS 4 requirement you discuss, I think.
You have to comply with 42 provisions.
The whole section is very much informative, so thanks the form, but we can have a PPT to the participant. I already told time again, PPT is not circulated. It is only the dissemination of the recorded webinar is actually circulated to all of you. It will be available to you. Post completion of the period, POD can dispose of in a manner, right issue, under section 62(1)(a)(3). Somebody put the information. So if the company receive money from the existing shareholder during the offer period, we will pass board resolution for allotment and file PSC 3. And can share be issued or renounced to the third party, and the money is also received after offer period, so that company can pass another board resolution for allotment and file another PAS form.
Once you close the
Sudhakar, it's very
offer, you cannot accept any more applications.
I think what the form is filed, I don't think there is any question of, recalling the form, etc. and other thing and all, unless something rectification is there, I think. I'm not very sure. Rajiv,
So
would you like
once
to
you
add
close
something?
the offer, Bala, you cannot accept any more applications.
Yeah, next.
What is the offer period in case of the private placement? Again, the valuation question has come.
To be decided by the board. I don't think for private placement, any timelines are given.
No, sir, no timelines are given. It is at the discretion. It's a private placement. So they want to execute, utilization of funds. So you need to keep a shorter period. It's logical out there.
Valuation question, I
Correct.
think we have answered here. Preferential allotment optionally converted preferential
Timelines given.
This also valuation, you talked about it. Valuation question I won't take now. BSE has raised the query that the right issue filing company has to file capital evaluation showing the forfeiture, either any format and from where we can get it.
It's very specific, actually.
Yeah.
I don't know. Alifia, you want to answer this?
Ma'am, in regards to capital evaluation, the format, whatever is there, though the stock exchange will only provide that format. So all the details have to be provided accordingly. If there is any mismatch, then this query is bound to come.
Okay, fine. Yeah, next.
That's all I think so. I've done with.
So I just want to mention here, if Balaji and Sudhakarji,
Yes,
please
yes,
correct.
100%, sir. 100%.
Please correct if I'm wrong. That any company, whether private, public, listed or unlisted, can go for the process of preferential allotment of securities, right?
Yeah.
Right, and I think it is the fastest way of raising the capital and increase the shares of the firm. And in case of winding up also, the that will be paid. They have a right to be paid before the common shareholders. So that's I think a little bit difference here.
Yeah, and Mr. Bala, we can take up
Yeah,
forms
some more question have come. Can we
and
open yeah.
questions we have left, no, earlier?
Yeah. Can we open simultaneously the right issue and the private placement at the same time?
Rights issue and preferential allotment.
Yeah, simultaneously at the same time.
No, private
Yeah,
placement and rights
it can
issue.
be, why not?
In case of the offer of the share renunciation by way of NOC or renunciation letter.
It can
by
be
the
done simultaneously, no harm.
Okay. In case of the offer of the share of renounce by way of a NOC or renouncement letter by existing shareholder, that is right issue under Section 62 of the Companies Act, then the board is entitled to dispose of this share to other person, which is not disadvantage to the shareholders and the company in such allotment of any other person of the right issue or private placement. I understand this is the private placement. Your views on this?
I think Sudhakar has answered this earlier only. This kind of question.
Yeah.
If renunciation, then what will be the implications and all that we discussed.
Okay.
Or Sudhakar, if you want to again.
No, nothing. See, board will come into picture only when there is an unsubscribed portion is there out of the rights issue. That when the board is disposing of that, it doesn't amount to private placement, and Section 42 provisions are not applicable because you cannot comply with. Section 42 provisions are entirely different. You have to open a separate bank account, the money has to come, you have to give an offer memorandum, whatnot and all. Can you do half the way? Can you do that, switch over the provisions? You cannot. So Section 42 is not applicable at all when the board is disposing of the unsubscribed portion. That is a part of the rights issue only.
One more thing, I think the question mentioned about giving some NOC with respect to renunciation. That is not again coming into picture because the offer document which is there, which talks about, subscription form and all, even renunciation form is generally mentioned over there.
Yeah, normally renunciation letter also goes along with that. That is the end of it. There is no separate document is to be generated. I think that's all, Dipti. If we can allow the people if they want to ask some question. I think there is one more question has come, I think so. Let me see, what is it? Either mandatory to allot the shares of the portion of the right issue, or it can remain as issued capital, which may be allotted later.
We will have.
See, as I told, if the unsubscribed portion is there, if there is anybody ready to take, yes, it can be. Otherwise, you have to cancel it.
Yeah,
you
that's
cannot
what you
leave
said.
it just like
Yeah, that's
that.
what you
Board
said
has
earlier,
to either
actually.
dispose it off or board has to cancel it. If it is cancelling it, then there is a difference between issued capital and paid up capital and subscribed capital. That will be there in the balance sheet.
Yeah, you did discuss this elaborately earlier also. Yeah.
Now,
Yeah.
Selvi, if I think no one has raised hand, but certain forms question is not answered, but it has gone quite behind. So, Selvi, if whosoever question as regard the forms, rather than going back, we allow them to speak if they want, raise the hand and just straightway ask the question.
No, form, in fact, PAS 4, PAS 3 was actually answered. In fact, he raised the question of GNL 2. Then he talked about the GNL 2 and the PS 4 was there. Thus, I think Sudhakar has answered that question.
It's all done.
Yeah, yeah.
Any question? I think, okay, fine. Then we can close, or anyone wants to raise the hand? Some comment has come.
I would ask Rajiv to share his thoughts because he,
No.
yeah.
Some question, comment is there. Can we take board resolution approval for issue of equity shares to
Yeah.
in one?
Can we take board approval for the issue of the equity share through the right issue and the increase in authorized capital? Board resolutions in one resolution.
Yes, it can be done.
PAS 4 need to attach in PAS 3. Okay. Is nil balance bank account required for private placement?
Yes.
Yes, it is. That's all I think, Dipti. Now
Yeah.
2 hands are raised actually.
Ah.
We can allow them to speak. I think one is actually Krishnan, another is Kanwal. Yeah, yes, Kanwal. Any one of you can speak. Unmute
You
yourself
can-
and speak.
Hello.
Yeah, please.
Good afternoon, sir.
Yeah.
Sir,
Yes.
basically, I have some basic questions. What is the difference between a private placement and a preferential allotment?
In my language, there is a saying. After listening the entire Ramayana, somebody asked the question, what is the relationship between Ram and Sita? So it is better you watch this particular recording on the YouTube and you will come to know the difference. This is on the lighter side, I am saying that, but if you want to know the differential between preferential allotment and private placement, it is entirely two different concepts. Maybe to some extent, the compliances may be the same.
Okay,
In
and
case of
for
private placement, as I told you, the board has to identify the group of persons. In case of preferential allotment, it may be to the existing shareholders, maybe to the promoters, maybe to any outsiders also. So preferential allotment means preferential over the existing shareholders. Private placement is entirely different thing.
okay, and
Okay.
for a private
It just
company,
it is that
yeah, yes, sir. So for a private company which is also unlisted, so in that case also private placement requires the this one shareholders approval.
Yes.
you have to comply with
Shareholders
42
approval
on
will be required. Definitely it will be.
yes.
Concluding remarks.
So concluding remarks in the form of poetry as right, that is being
Welcome, sir.
always.
Welcome. Most welcome.
So we have actually discussed the startup issues and other things. So this poem is related to the little bit of startups and the things which we have discussed, and small appreciation to you, right, for Mehta and Mehta. So I'm just starting here. Am I audible if I'm not wrong?
Yeah, very much, very much. Go ahead.
So in the realm where startups dream to rise, amidst the challenges that test the wise, private placements, rights, and allotment preferential stands as pillars, capital's potential essential. Yet startups face hurdles, their path unclear, limited resources, regulations austere. But fear not, for technology lends a hand with platform innovative compliance at hand. Crowdfunding embrace, where dreams take flight, angel investors guiding startups to light, digital solutions, paperwork made small, legal hurdles conquered, compliance for all. Yes, heed the caution, yet heed the caution, lest penalties loom, ROC's watchful eye in regulatory room, cases untold where startups fell astray, for compliance neglected a heavy price to pay. So startups take heed in this poetic tale, navigate wisely, let compliance prevail. With the technology's aid and regulation in sight, thrive you shall in the capital might. In this, in this journey of knowledge and insight, let's extend our appreciation bright to Mehta and Mehta firm and their speakers too for guiding us through and sharing what's true. So that's my take, call and conclusion call.
Great,
It's
sir.
wonderful.
Great, great.
Thank
I
you.
must
Thank you,
definitely
sir.
appreciate, apart from your professional thing, your Kavita's excellence. Excellent poet you proved to be. Great,
And
sir.
you were guided to startup so well that, and how the ease in borrowing on digital impact, everything you penned very well in one line, one flow.
Very important for them also to seek help from you, from your professionals. You are so expert in this field, so I must say that this is a message to them.
Thank you, thank you,
Thank you. Thank you so much.
No doubt, Rajiv, the great credit goes to Dipti, along with Atul and her team's support. We have been actually doing it almost now closer to 2 years. Every
Great.
Saturday, meticulously, barring 1 or 2 long holidays, we have been doing it excellently in the different topics. And I am very much overwhelmed to see the number of participants who are actually there, because that actually brings, knowledge spreading and awareness of the people, especially who are there. I see a lot of youngsters who are actually joining it. It's a wonderful thing which Mehta is doing it. So your appreciation is definitely 200% correct, Mr. Rajiv. Hats
Thank
up to Dipti. I am also delighted to be a part of you.
Your blessings and everyone's good wishes, we are able to do that.
And very good
yes.
and very good and detailed presentation by Kripal.
Yeah, Kinjal has done an excellent homework actually. She has covered everything A to Z, bringing out the things, including the principal issue. Great thing, Kinjal. Appreciation
Thank
to
you. Thank you so much, sir.
And thanks for inviting me here to be a part of this part.
Dipti, your last word, we can close.
Yeah, thank you, Mr. Rajiv, for your wonderful note, your inputs. Thanks for that. Sudhakar is not there, but as usual, he is a Yuvraj. He has given all 6 in 6 balls and sixers. Thanks, Mr. Bala, for in between your intervention and your inputs. And Kinjal, as usual, you were always in depth of the subject. We discussed yesterday and you were telling I'm touching this also, I'm touching small scale also, I'm touching this also. Otherwise, it's a actually procedural aspect in this. And we were talking that same board meeting and AGM, but only valuation report was continuously coming, which very well cleared. Thanks a lot. Even though it was a Companies Act only, we have covered also LODRs. He mentioned that I will surely cover, though we are talking Companies Act. Very well done, Kinjal. Thanks a lot. All participants, thanks a lot for your participation. Keep on, encouraging us this way. And if any participant, your question is not answered, I apologize. You can very well put us to us. The same will be individually answered. Thanks a lot. Thanks, everyone. Thank you.
Thank you. Thank you, everyone.
Thank you, Mr.
Bye.
Batu, again.
Have a good weekend.
Yeah.
Thanks a lot to everybody.
Thank you.